Hello, everyone, and welcome back. This is our final panel. It's kind of hard to believe that we're already at our fifth and final panel of this weekend. We're going to start off the panel like every other with our access statement, just to explain all of our access guidelines and features that we've done throughout the symposium, but for this final panel as well. We strive to be as inclusive as possible. To that end, here is some information about how this panel will go. We have ASL interpreters, Donna and Joy, and also manual closed captioning as standard accommodations for each panel and speaker during the symposium. We will orally identify ourselves. I am Matthew Seelig. When we are speaking for the first time, we will describe our visual appearance. And in all instances, we will state our name before we speak. If a speaker shows a slide, they will describe and explain what is on the slide. We encourage participants to use plain language whenever possible and avoid acronyms or avoid using them altogether. We have a few channels for asking questions. Anybody may type a question in the Q&A tab, and that is the Q&A tab and not the chat, which we want to reserve for access, technical, or logistical communications. We will have a moderator read questions unless the person asking the question prefers to ask orally. To ask your question orally, please indicate you would like to do so in the body of your question, or alternatively, you may simply raise your electronic hand. We will then allow you to unmute yourself and ask your question. Finally, we have a phone line where anyone can call in to ask a question. That number is 215-898-7060. You may also use this number to make any accommodation requests or report technology issues. You may also alert us to issues via the chat. This panel has CLE, continuing legal education associated with it. So I will call up Vanessa to make our first CLE announcement. Vanessa?
If you're seeking CLE credit for today's event, please note that CLE passwords will be announced twice per hour. Write down these passwords and enter them on your digital evaluation form once the event is over. The evaluation form is mandatory to receive CLE credits. The link to the digital evaluation form was emailed to you in your event reminder email. If you did not receive the email, please find the link to the evaluation form in the chat. These passwords will tell us how long you attended. The first password is GOAL, spelled G-O-A-L.
Thank you, Vanessa. All right, again, this is the fifth and final panel. It is about the future of the disability frame. You will hear remarks from Ruth Colker, Doron Dorfman, Robyn Powell, and Britney Wilson in that speaking order. Dorothy Roberts will then deliver a short comment and invite questions from the audience. Biographical information about the participants is available in our symposium program, which is on our Dropbox, and I'll share that in the chat momentarily. It's now my pleasure to give the floor to Professor Colker.
Well, thank you, Matt. Thank you, Letitia, for all of your work in putting this symposium together, and thank you to everyone else who worked on this. I know it takes a huge amount of effort, and you did it twice, both make it in live and then have to switch to it being online. So thanks so much for your work. I really appreciate it. My name is Ruth Colker. I have a short, I was going to say gray hair, but I can see some brown, so maybe I can say salt and pepper, with red glasses. And if you had really good eyesight, you would also be able to tell that I have uncorrectable strabismus, so my eyes sort of move back and forth sometimes, but that's fine, that's cool. Gave me some opportunities as a child to know what it's like to have people throw epithets at you at the swimming pool. So today I'm going to talk briefly about the future, which is what we're supposed to be talking about in terms of what disability justice might mean as we move forward. And I'm going to talk about two concepts that are Latin, but I'll translate them, which would be ex ante, which means beforehand, and post hoc, which means afterwards, or I would say afterthought. And both of those concepts are part of the ADA. And what I want to suggest today is that moving forward, we need to think about how we can better take advantage of what I would call the ex ante principles, in part because those principles, I think, can best advance disability justice and be intersectional in moving us forward. So what do I mean by these two concepts? So the post hoc concept is one that everyone is familiar with. We usually call that reasonable accommodations. In that situation, you'd have to identify as disabled, request an accommodation, and then on an individual basis, you would get an accommodation. There's been some discussion today and yesterday about the costs of accommodations. I argue in my article that in fact the costs are higher than the disability community often will be willing to acknowledge. And I can see that for political reasons, but I also get annoyed when people sort of make up facts. So you can read my article to see why I criticize the most commonly cited estimates of what reasonable accommodation costs. But my bigger critique of accommodation has nothing to do, of course, with the cost. I think that any cost is one that we should pay if it's necessary to facilitate access. My problem with it is that it's much more of it's much more of a individualized solution rather than a structural solution. By contrast, ex ante solutions are also in the ADA and maybe don't get enough attention when we think about the statute. When we think about ADA Title III, which is really my favorite part of the statute, the one that creates accessibility to entities that are open to the public, in that situation, the statute requires that when architects and engineers design buildings, that they design them with people with disabilities in mind, and they design them with the ramp, with all the devices that are necessary to help create access, so that we then don't have to come in afterwards and retrofit the facility, which is much more expensive than to just design it to begin with to make it accessible. As David Furlinger mentioned earlier today, when we do that, when we create the curb cuts, we create accessibility, we don't only create accessibility for people with disabilities, but we create accessibility more broadly. And this conference has been a perfect example of what that can mean, because by thinking about people with disabilities and the design of the conference, this conference has been more accessible to all of us, irrespective of whether we have a learning disability or ADHD or a visual impairment. All the steps that have been taken have just made this a better conference. And I've written about universal design principles in the classroom and how that just creates better teaching for everybody. And so ex ante principles, I think, are very important, and they create access more broadly to the whole community. And one reason I became discouraged with the more reasonable accommodation way of thinking is because of some of the work I've done in the special education field. And for those of you interested in that work, I wrote a book called Disabled Education. It came out in 2013, but I think it's still relevant today. And in the book, I discuss how, as a middle-class white parent, I could use the courts to receive for my child to receive accommodations in the classroom. I shouldn't have had to go to court. He should have gotten those accommodations as a matter of right. But I knew by doing that, I was able to access my privilege as a middle-class white person. And I knew that there were many other students in the community who weren't getting the support that my son was getting because they didn't have access to those kind of resources. So instead of doing this one person at a time model, if instead we designed the classroom to be more accessible, it helps a really broad class of people. So let me quickly pivot to a contemporary issue that I think demonstrates the importance of my thesis. And it's not one that I write about in my draft paper for the Penn Law Review. And that's this new SET that some of you may have heard about. And for those of you who have teenage children, you probably are especially attentive to it. Others of you may be sighing relief and not having to think about the SATs anymore. But the so-called new SAT is going to be shorter, and they're going to use computer adaptive technology. And I don't need to get into the details. But let me just say this, it's going to be a massive failure for people with disabilities, students with disabilities, for reasons I could discuss in the Q&A. It's going to be massively unfair to low-income students, racial minorities who are already negatively impacted by the SAT. We know there's a direct correlation between your income level and your score in the SAT as a predictor. And so as a disability rights advocate, I could work with students and try to help them get extended time and accommodations to improve their scoring on that test. But I think what makes more sense is for us to come together as a community across various interest groups and argue that colleges need to just get rid of the test itself. And fascinatingly, in California, they have gotten rid of the test itself at both the state and college level. And I was interested to hear Rebecca Coakley say earlier how she didn't go to law school because that LSAT was a barrier for her. So I looked up her bio, and Rebecca went to UC Santa Cruz. And so I just want to tell Rebecca that if she applied to UC Santa Cruz today, she would not have to submit an SAT score. They will not look at the score. And that to me is a huge advancement in civil rights justice, broadly speaking, including disability justice. And that is different than saying we'll be test optional, because the data indicates that test optional practices actually privilege middle-class white students, as always. These things always do. And so if we really want to help move towards broader access to education, we need to be moving this community to argue through legal arguments, through political arguments, whatever arguments we have available, that this test just needs to be ripped up and get the F that it deserves so that we no longer use it. So that's just an example of what it would mean to have an ex ante approach, which is let's just get rid of the test, rather than a post hoc approach of trying to get accommodations one student at a time. So those are my thoughts for today. Happy to talk more about it in the Q&A, but I really wanted to make sure we have enough time to hear from these brilliant panelists that are part of the conversation today. So Professor Dorfman, I think you're next.
Thank you so much, Professor Colker. My name is Doron Dorfman. I use he and him pronouns. I'm a white male with wavy dark hair and turtle brown square glasses. I'm wearing a white shirt and a plaid tie in green and white, and a gray jacket. And you are in my living room at my house in Syracuse, New York. And I'm just thrilled to be here. Thank you so much for having me. And thank you so much, Professor Jasmine Harris and Professor Karen Tenney and Matt Sealing and Leticia Zalzer and the whole people at Penn Law Review for organizing such a terrific event. And I'm also honored to be on a panel with two of giants, I think, in the field of health law and bioethics and disability law, such as Professor Roberts and Professor Colker. And I'm so happy to be here with other people, other younger professors who I admire, Professor Robyn Powell and Professor Britney Wilson. And I'm just thrilled. I have a huge smile on my face. So I'm a disability law scholar, but I'm also a law and psychology scholar. And I'm interested in cognitive processes and decision-making by legal actors. And I was therefore fascinated by what causes scholars and advocates to use the disability frame, meaning to try and fit other categories that are not people with disabilities, like people of color, trans people, poor people, pregnant women and pregnant persons, under disability law as a strategy. And although this attempt at expanding the term disability under the law is not new, in a piece that Rabbi Abelt and I published in 2020, we argued that the current wave that we see of using the disability frame that I think sparked this symposium was done because of the Trump administration making it extremely difficult to obtain civil rights protections. So people had to find other avenues through law and found disability law. In my series of papers on fear of the disability con, specifically in a paper called Unusual Suspects, I claimed that it is the allure of positive rights given in the form of accommodations under the Americans with Disabilities Act. And those are specifically different in an American legal system that really is based on negative rights that attract scholars and advocates to disability law. And I think those explanations, those reasons for using the disability frame are correct. But in this piece I'm currently writing, I want to offer another explanation to the question of why we see this wave of people using the disability frame. And some people use the word co-opting, and it might be so in certain situations. My explanation, my new explanation in this piece has to do with language, with metaphors, and with cognition in legal discourse. And the name of my new piece is Disability as Metaphor in American Law. And I want to start with an anecdote from my personal experience in academia. When I started my doctorate, when I arrived at Stanford, arrived in the US back in 2013, There was no one at the entire university, no one at the entire Stanford campus who did work on disability studies. Currently, we have great people, but way back when, there wasn't anyone. And when I went around in the law school and in political science departments and in sociology to try and find colleagues, and I said, you know, I work on disability, scholars immediately say, oh, you mean you work on Social Security benefits and welfare policies? You know, like the term going on disability. Now, as a non-native English speaker, I immediately thought that I was saying something wrong and that the language that I'm using might not be appropriate. And I immediately said to them, no, I deal with disability and the social and cultural aspect of disability in multiple contexts. But it was to no avail. At that point, people who were not attuned to disability studies and disability rights or disability justice were not really understanding what I'm talking about. It's as if they could not have looked past by the term disability as a metaphor for social benefits. And that experience really stuck with me. And I'm happy that I finally was able to translate it into a theoretical argument, which I claim could be added to the reasons people seem to feel comfortable using disability as a metaphor to carry it over to other type of disadvantages. So disability is a polysemous word. It's a big word that only means that it has many definitions in American language, one of which relates to the inability or disadvantage. And this lexical ambiguity predates the Disability Rights Movement and Section 504 to the Rehabilitation Act and the ADA and its definition of disability. And I claim that the prominent use of the term disability to mean something else other than people with some kind of an impairment, meaning as a metaphor for disadvantage or inability more broadly, has helped instill the view that the concept is much broader than what the legal definition actually allows. And I don't mean to refer to the use of ableist language and disability metaphors in everyday life, like my brilliant friend Jamelia Morgan talked about earlier today, and other scholars like Lydia X.Z. Brown or Vivian May and Bess Ferry, my colleague here in Syracuse, talked about in their work. And I'm talking about metaphors like falling on deaf ears or the crippling economy. That's not what I mean. I am talking about the way legal actors, specifically judges and legislators, have used the actual word disability to mean something else than what the ADA definition actually meant. And I bring three examples of categorical examples of such use by courts and legislators that I think we all heard about in the past, but we didn't really pay much attention to them. And it shows to me how ingrained the use of disability as a metaphor is in the legal system and legal discourse. So my first example is the topic of legal disabilities, meaning the inability to file a legal claim. So infants, married women, or prisoners have or had at some point in time an inability to sue, to file a claim. And courts literally call this a disability. Second, when a legal actor cannot proceed to fulfill a legal role anymore, they need to step down due to a reason that has nothing to do with a health condition or an impairment, something like conflict of interest or recusal. Some courts and legislators call this situation a disability, quite literally. Thirdly, in multiple constitutional contexts, when a group is faced by some kind of hardship or discrimination, courts have referred to such an impediment, right, such a disadvantage, literally as disability. And I like to give the example of the famous case, Rumor versus Evans, which is a Supreme Court case. It's a famous LGBTQ gay rights case, where Justice Kennedy wrote that the amendment to the Colorado's Constitution that stood at the heart of the issue creates, and I quote, broad and undifferentiated disability on a single named group, end quote. And that group was not people with disabilities. There were gay people and LGBT. So why is it so important? Why am I looking at language so much? Why do I care about this use of the literal use of the word disability in legal discourse? Well, because cognitive theory tells us that metaphor affects our understanding of the world, even unconsciously at times. Metaphors shape the way we think about politics and criminal justice, for example, and other areas. The classic example in the literature is in the Holocaust, when Nazis used Jews as a disease within the body of the people, or in criminal justice, when we turn criminals into animals that prey on the unsuspecting victims. That really triggers something in our minds and the way we think about the category. And this panel deals with the future of the disability frame. And I think, we also had a panel about the past and the history. And I think the future cannot ignore the past and the way in which language has taught us to think about disability as such an all-inclusive metaphors that cover disadvantages and disadvantaged group in a variety of contexts outside of people with impairments. So there's no wonder why legal scholars and advocates who might not be immersed in disability rights law find it so easy to apply the concept to other groups. They are just used to it, even subconsciously. And my lesson for the future would be to be aware of this and to bring it forward and to avoid disability as a metaphor, at least when possible, to make sure that nowadays in the 21st century, when we say disability in the legal discourse, we actually mean referring to people with disabilities as a protected legal class that got its protected legal class after many years of advocacy and a history of a very important social movement. And I thank you for bearing with me, and I'm very much open to comments or suggestions as this is still a work in progress. Thank you so much for the opportunity. And I think I'm gonna move it forward to, is it Robyn? Is Robyn after me? Yes, go ahead, Robyn.
Thank you, and wonderful so far. My name is Robyn Powell, and to give you a description, I am a white woman in a power wheelchair, and I have a teal shirt on and apparently very frizzy hair thanks to Florida weather. So frizzy brown shoulder length hair. So that is what I look like, and my pronouns are she, her, hers. And I want to, thank the University of Penn Law Review. I think this has been such a fantastic past few days. And Professors Tani and Harris, I thank them wholeheartedly for everything they've done to really put this together. And I think it's important to recognize the almost 200 people that are spending their Saturday with us. So thank you to everyone here who is really spending their time with us. And I want to just also give a shout out to the panel before this who are practitioners. As someone who practiced law for several years, I think that the Legal Academy needs to listen to practitioners more. So keep pushing us. I want to begin by telling you something that I think everyone here knows, which is that reproductive rights in the future of them in the US are fairly bleak. And I don't try to be a Debbie Downer, but I think it is fairly accurate. And we see, from a growing number of states who are trying to pass draconian state laws that really drastically limit and in many cases ban access to safe and legal abortion care, to a Supreme Court that is poised to really overturn Roe v. Wade, we see that reproductive freedom is under siege at every turn. And I think that this really difficult reality has really elevated for us, all of us, the importance of reproductive rights, really, and why we need to care about these things. And at the same time, I think it's important to recognize that the discourse concerning reproductive rights has always been really narrowly focused and has really failed to recognize the really broad scope of reproductive decision-making beyond abortion. And so in addition, I think it's important to recognize that the reproductive rights movement has traditionally overlooked the myriad other ways that marginalized populations, including disabled people, experience reproductive oppression every single day. So my paper really looks at these issues, and I think I did so mainly because it's very timely. So when we think about disability, and we, I don't mean us, but the broader society, when we think about disability and reproductive rights, and especially abortion rights, people tend to think about disability abortion reason bans. That is when people who are typically presumed to be non-disabled want to terminate a pregnancy because of a fetal disability diagnosis. And really, to be sure, there have been significant tensions between disability rights and reproductive rights movements. And I don't want to really dismiss those tensions. I'm a disabled woman, first and foremost, and I think that those tensions are really important to recognize. At the same time, as the prior panel really emphasized, it's important that we coalesce the movements. We need to start coming together. And I think that we can do that in this area. So I really call for in my paper the coalescing of reproductive rights movements and disability rights movements, and explain how we need to really include also expanding the fight for reproductive freedom beyond abortion. And I really draw from reproductive justice to do so. And so just to bring this into a really timely way, we can see that recent revelations about Britney Spears' battle to end her conservatorship, I think, illustrate a common way that reproductive freedom is legally denied to a lot of disabled people. And I think her experience does reinforce why we need to take this comprehensive approach to fighting for reproductive freedom moving forward. And we could get into a discussion about where Britney Spears fits in this definition of disability, and that's for maybe a later conversation. But right now I want to recognize that she was placed under conservatorship in 2008 because of a mental health crisis. And then for the next 13 years, she really had her conservators exercising complete power over everything she did. And in June of 2021, she really, I think, stunned the world when she delivered this really heartbreaking statement, begging for the court to finally overturn her conservatorship. And when she was doing that, she listed a wide range of injustices that she had suffered. And one of them was that she wanted to get married and to have more children, but she couldn't because her conservators would not allow the removal of her IUD. And unfortunately, the world seems shocked by this, but unfortunately what happened is that's common for a lot of people with disabilities. And of course, because of Britney's tenacity, as well as significant resources and public outcry, including a hashtag, her conservatorship was terminated in November. And while this eventually positive outcome is great, it doesn't negate the fact that for more than a decade, she was denied her reproductive autonomy because she has a disability. And it's also important to recognize that most people who are subjected to conservatorships don't have Britney's platform, they don't have hashtags, and they don't have resources. So it is incredibly difficult to really overcome these restrictive legal arrangements. So although her experiences with conservatorship may not at first glance seem like a reproductive rights issue, what happened to her is neither unique nor uncommon. In fact, the belief that people with actual or perceived disabilities should be denied reproductive autonomy has been really a persistent, unrelenting issue throughout our nation. And each day, sexuality and reproduction is weaponized to subjugate people with disabilities through a wide range of things such as forced sterilization, coerced abortion, inadequate access to sexual and reproductive health services and information, and something I'm really concerned about, which is surveillance and regulation of parents with disabilities. And for people who live at the intersection of multiple historically marginalized identities, these reproductive injustices are even more pronounced. And unfortunately, I think the reproductive oppression that disabled people experience is really woven into our laws and our policies and really our collective consciousness. And so we need to really dismantle the systems that propagate these injustices completely. And we need to really create a society where all people are afforded their fundamental right to decide whether to have a child or not to have a child, and be able to raise that child with safety and dignity. So in my paper, I, of course, begin by sort of looking at the historical underpinnings of the reproductive oppression that are experienced by disabled people. And of course, I start off with the eugenics movement. And in that section, I think that history has shown that disability has always been used as a justification for subjugating reproductive freedom. And we can see even with Buck v. Bell, someone who ultimately did not have a disability, but was perceived as being quote unquote feeble-minded to justify the sterilization of her. And while I don't want to waste time talking about the past, since this is the future panel, I think it's important that we recognize that. So here we are almost 100 years since Buck v. Bell, and disabled people continue to have their sexual and reproductive needs and rights ignored. And I think part of that is because disabled people are not perceived as sexual beings or people who want and can have children. And so in my paper, I identify 6 areas that I think illustrate the contemporary reproductive oppression experienced by disabled people. And they are, first, of course, that disabled people experience a wide range of sexual and reproductive health disparities. And that results in really significant high rates of sexually transmitted infections, poor maternal and child health outcomes, and just inaccessible healthcare. And so that is something we need to look at. The second one was really that there's a scarcity of comprehensive and accessible sexual education. Most special education curriculums omit sex ed completely. And when we do provide sex ed to disabled people, it tends to be reactive rather than proactive. The third is that disabled people, like Britney Spears showed, are still denied reproductive decision-making. The fourth one, which I think really is a framing issue in a lot of ways, is barriers to contraception and abortion. And of course, the conversations around abortion and access to contraception for disabled people really do invoke a complicated history. And on the one hand, we see that research indicates that disabled people have a wide range of barriers to accessing contraception or abortion. And on the other hand, many, like Britney Spears, are forced by guardians to use contraception or to have abortions. And I think the thread that brings these two really opposite approaches is that disabled people are continuing to be denied their reproductive freedom. And the fifth thing is then that disabled people continue, as I said, to really be denied their right to exercise their sexuality. Group homes, for instance, often do not allow individuals with intellectual disabilities to engage in sex. And that's just one of many examples. And then finally, the threats to parenthood and the child welfare system, which Professor Roberts and others more accurately term the family policing system, really does surveil and it punishes marginalized communities, including disabled parents. So I've just sort of told you all the bad things that are happening. So what can we do about it? So I think we need to draw from both reproductive justice and disability justice and really move forward as a community. And I identify 5 principles that I think are needed to finally achieve reproductive justice for disabled people. And the first is that we need to ensure that our legal and policy solutions are aimed at disrupting intersecting oppressions. Disabled people who live at the intersection of multiple historically marginalized identities are experiencing the most oppressions. We need to start there. Second, we need to ensure that activists and scholars and legal professionals and policymakers actively engage people with disabilities in establishing legal and policy responses. Third, we need to ensure that these policy and legal responses are developed and implemented in a way to guarantee that disabled people's rights to autonomy and self-determination are protected, and things like supported decision-making would be one way. Fourth, we need to ensure that sexual and reproductive health services and information is fully accessible and available for disabled people. And then finally, we need to ensure that disabled people are ensured their rights, their justice, and wellness for both themselves and their families. And so while it's really an awful time for reproductive freedom in the United States, I think it's also one of immense possibilities. And I think with respect to framing of disability, we need to recognize disabled people as sexual beings and possible parents that are deserving of reproductive freedom. And we also need to address the tensions between the disability rights and reproductive rights movements. And I think that disability justice and reproductive justice collectively allow for this. And in fact, they require this. I think one of the things I want to end with is really when we move forward with fighting for reproductive freedom, we need to ensure that anti-choice activists are not using disability as pawns. Far too often we're seeing that. And so I really look forward to the questions afterwards. And at this point, I'm going to turn over to Professor Wilson.
Thank you so much, Professor Powell, and good afternoon. My name is Britney Wilson. My pronouns are she, her. For my visual description, I'm a Black woman wearing a green blouse and a dark gray blazer. I'm also wearing black and gold rimmed glasses, and I have black hair that's in 2-strand twists. I'm sitting in a room with yellow walls. I also want to thank Professors Harris, Tani, and the editors of the University of Pennsylvania Law Review for having me. Although you can't see it on camera, I'm also disabled. I was born with cerebral palsy. I walk with arm crutches, and I use an electronic scooter to travel long distances. And I'm also a Penn Law alumna, so I'm especially grateful to see this much needed recognition of disability taking place at my alma mater and to be here with Professor Roberts in particular. And since I have the benefit of going last, I'm going to try to do something a little bit ambitious, and that is be in conversation with my fellow co-panelists in my remarks. But I'm going to discuss the use of disability as both fearsome villain and innovative legal strategy in environmental justice campaigns. The title of my forthcoming article is Making Me Ill, Environmental Racism and Justice as Disability and Disability Justice. And specifically, I'm going to talk about the framing of environmental justice advocacy, be that litigation and otherwise, in terms of the fear or threat of disability, and then the use of the Americans with Disabilities Act and other disability rights laws to advance legal claims for environmental justice. I also had the benefit of listening to Professor Dwyer Reynolds' remarks earlier on disability and environmental law, and I hope that my remarks will be a useful addition to that conversation. But I also wanted to note that my remarks focus on environmental justice and environmental racism. And when I say environmental racism, I'm specifically referring to environmental harms that disproportionately affect communities of color. And when I say environmental justice, I'm discussing advocacy against these harms that's specifically led by and/or made up of predominantly people of color. Professor Robert Bullard, who's often called the father of environmental justice, defined environmental justice as a framework and practice that examines and challenges the inequitable distribution of environmental protection. It poses the ethical, political, and social questions of who gets what, why, and how much when it comes to pollution, sanitation, and other forms of environmental harm and degradation. And I think that definition, which focuses on the expansiveness of environmental justice and frames it in terms of resource allocation, is particularly helpful in facilitating a conversation about racism and ableism, which my remarks will also aim to do. And also, unlike Professor Dwyer Reynolds, I should say that I'm a very recent and completely accidental environmental justice advocate. My background is actually in federal civil rights litigation. I very recently made the transition to academia as a clinical law professor. So I'd like to think that I'm the bridge from the last panel to this one between practice and academia. And my practice in federal civil rights litigation largely had to do with racial discrimination more broadly, the school to prison pipeline, the criminal legal system, and policing. And in terms of disability rights, I've largely done a lot of Olmstead work, the Supreme Court decision in Olmstead, around the provision of home and community-based services for people with disabilities and some disability discrimination in healthcare. So you might wonder, how did I get to talking about environmental justice? And basically what happened was I'm a native and resident of Brooklyn, New York. And for more than a year now, I've been working with and supporting literally my neighbors in opposition to National Grid's construction of a fracked gas pipeline in the middle of predominantly low income and communities of color in Brooklyn, the pipeline we call the North Brooklyn Pipeline. And my clinical students.
Professor Wilson, would you mind slowing down just a touch? We want to make sure that our interpreters and captions can go. This is Matthew, by the way. Thank you.
Sorry, I will slow down. So my clinical students and I, along with our co-counsel at the National Center for Law and Economic Justice, filed a complaint challenging the pipeline under Title VI of the Civil Rights Act of 1964 and the United States Department of Environmental Protection, the Environmental Protection Agency, and the United States Department of Transportation, specifically their Pipeline and Hazardous Materials Safety Administration, are currently investigating our complaint. And although environmental justice hadn't been my area of professional expertise, I was always interested in and drawn to stories about environmental justice because it seemed like there was always some story in the news about a community of color facing some toxic or hazardous thing in the neighborhood that was making them sick. And so in the course of doing that work, I started to interrogate the root of my own interest in environmental justice as a Black disabled woman and as someone who litigates and advocates in the area of disability rights. And I've also gotten to learn a lot about the history of the environmental justice movement in communities of color. And so that exploration led me to a body of literature, largely in the social sciences that critiqued the framing of environmental justice in terms of the fear or threat of disability. And that led me to be able to articulate my own interest in this area. And that basically is that stories of environmental injustice are often framed as stories about the affirmative disabling of people. So in my remarks today and in my written contribution to this symposium, I wanted to explore the implications of that framing, particularly for people of color with disabilities and for litigation and advocacy strategies as a whole. And I should say, for the purposes of my talk, that I'm using the terms disabled and chronically ill interchangeably, and I'm defining disability as it's defined under the Americans with Disabilities Act, that is, as a physical or mental impairment that significantly limits one or more major life activities. And so I'm gonna try do what I said I was gonna try to do, which is incorporate my colleagues' discussion a little bit into my own. And I start my article talking about the framing of disability in terms of the fear or threat, the framing of environmental justice in terms of the fear or threat of disability. And the examples that I use, I start off with the case that's seen as the beginnings of the origins of the environmental justice movement. That's in Warren County, North Carolina. Specifically in 1978, some truckers disposed of an illegal chemical known as PCBs. I don't even remember what the chemical stands for, along 210 miles of the North Carolina freeway. And after that dumping occurred, the state of North Carolina had to figure out what to do to clean up this toxic spill. And the state of North Carolina, along with the Environmental Protection Agency, had to make a choice of where to dispose of the toxic soil. And they went through a selection process where they reviewed something like 100 counties in North Carolina across 13 cities, and they chose the disproportionately Black, low income, and politically unrepresented Warren County, North Carolina. And the community organized first to stop the selection of their neighborhood as the place for the landfill, and then after the soil was ultimately dumped there. And there are lots of stories about how politically active the community became in trying to stop this action from happening. And specifically in discussing how active the community was, they said everyone thought that as soon as the soil was dumped in our neighborhood, we were going to get sick. We were going to get cancer. There are stories of children, 10-year-olds, 4-year-olds being arrested, crying, saying, I don't want to get sick, I don't want to get cancer. And so that was the beginning of my thinking of, oh, wow, this is how environmental racism is made to be a serious issue in communities. You equate it with getting sick or getting disabled. And then I started to see other examples. I used another one in my article in Brownsville, Texas, where a community in the late 1980s, early 1990s that lived just across the Rio Grande River from American-owned factories called maquiladoras started to have babies that were born without brains and babies that were also born with a disability known as spina bifida. And that framing, the community filed lawsuits. They were never able to ultimately make the specific causal connection between the maquiladoras and the pollution into the river that came from the maquiladoras and their children being born without brains or with specific disabilities. But that was a huge part of the framing of this community's fear of the link between the toxins that they were exposed to and disability. And then specifically in my paper, and I'll get to this a little bit later, I talk about the community in Louisiana, literally known as Cancer Alley. And so we see, and Cancer Alley is a place where the community there has a disproportionate number of toxic chemical facilities and a specifically high incidence of cancer in their community. And in the 1990s, I believe it was 1998 in particular, they fought another petrochemical plant coming into their neighborhood under the ADA. But I'll talk about that lawsuit in a little bit. And again, even the use of the name Cancer Alley, you see a community using the moniker and the language of the fear or threat of disability to advance the cause of environmental justice. Now, let me just say, obviously, I'm not saying that there's anything wrong with someone not wanting to get sick, not wanting to get cancer or any other form of chronic illness. I'm using these examples to show how disability as a negative, as a monstrous thing that results from environmental harm is used to advance the cause of social justice, often in communities that don't often or aren't necessarily advocating for disability more broadly. And I wanted to use that to tie into what Professor Dorfman discussed in terms of disability as metaphor. So in this instance, disability is not exactly a metaphor. It's literally a narrative or rhetorical device that is used for either organizing purposes, and then as I'll discuss a little bit later, literally for litigation purposes and strategy. In making this argument, I trace the origins of environmental justice as a public health concept because environmental law is a branch of public health. And we know that there's a long history also of tension between the public health and the disability advocacy community. So this is where I'm going to bring in or try to bring in what Professor Powell discussed in terms of the tensions between movements that are often informed by one another. So in the public health space, the whole goal of public health is to keep communities, quote unquote, healthy, and disability is often framed as in opposition to that. And so it wasn't hard to understand why those communities would be in tension. But as I looked at the origins of environmental law itself, I started to see its racist and ableist roots. And specifically, environmental law in the late 19th century, as America began to move from the frontier, you had advocates literally use disability to try to say that, okay, there's an image of an American that is fit, that is robust, that is morally superior, that should stay on the frontier and not move to the cities because the cities are going to be dangerous. You have the harms of industry that are going to make you sick. But you, rugged, fit American, should stay on the frontier. And so I started to make those connections between the origins of public health and along with those images of what it meant to be a fit American or able-bodied, non-disabled American, also came the images of what a true American was, and that often meant white. or not a person of color. So again, you see the connections between ableism and racism. And as I began to think about how environmental justice movements use disability, I thought about the risks of movements that are rooted in your obsolescence, if I could say, using your rhetoric and using your legal devices for their own benefit. And I'll come back to that hopefully a little bit later as well. And the origins of the environmental justice movement in terms of legal strategy were interesting as well, because as communities started to talk about the harms of environmental injustice on communities of color, it made sense to use race-based litigation strategies to get those points across. The environmental justice movement in and of itself began in the 1970s, which was sort of just after the heyday of the civil rights movement, if you will. And as they started making these connections between environmental harms and communities of color, they said, oh, wow, since environmental harms are disproportionately affecting communities of color, why don't we use race-based civil rights litigation strategies? And you started to see that. And courts, we're amongst a bunch of lawyers, so all the lawyers on here know how difficult it is to prove race-based discrimination and that you have to prove intent. And really interestingly, if we follow the timeline of those environmental justice cases in the 1970s, we know that somewhere around 1977, the Supreme Court decided Village of Arlington Heights, where it specifically enumerated the factors that were required to prove intentional discrimination. So it became really, really difficult to prove intentional race discrimination, and people started losing these environmental justice, race-based discrimination cases. So that's the 1970s and 80s. And I'm going to bring back Professor Dorfman's comments again, because he talked about the disability frame coming about as a response to Trump. And my article sort of chronologically traces its origins maybe to a different time. So you have the 1970s and 80s, you have Village of Arlington Heights, and then I'm going to skip ahead a little bit. In 2001, the Supreme Court decided Sandoval, where it specifically did away with a private right of action for Title VI claims, specifically Title VI of the Civil Rights Act of 1964 and disparate impact claims. So after it became really difficult to bring environmental justice-based, race-based discrimination claims under intent, advocates started to use Title VI, and that was short-lived. So that was the 1970s. First, we have 1970s and 80s foreclosing intentional race-based discrimination. Then we have the early 2000s, where you foreclose disparate impact race-based discrimination. Well, what happened between the 80s and the 2000s? 1990. And in 1990, the Americans with Disabilities Act was passed. And so I talk about in my article specifically some cases that were brought in between that time and after that time using the ADA to challenge environmental justice issues. And I'm sure I'm still talking too fast, so I'm gonna take a pause here and say that the first case that I discuss is called Lewis v. Foster, and it was actually brought by one of my former employers, the Center for Constitutional Rights, in 1998. And that case was brought on behalf of the residents of Cancer Alley, communities of color that had asthma, cancer, and other health conditions. And they challenged that chemical plant that I mentioned. They tried to stop the Louisiana Department of Environmental Quality from issuing an air permit to that plant. And they brought that claim under the Americans with Disabilities Act, specifically Title II. And they said, we're already disabled. You're going to exacerbate our disabilities. You're depriving us of the protection of the state, because it's your job to protect us, to deny this permit, and you're not doing that. Ultimately, that case was never litigated because the community's organizing was so strong that the company withdrew its bid. But I think it raises really interesting questions about the use of disability, the ADA, and the disability frame. First, what are the affirmative obligations of the government to protect people with disabilities from environmental harm? Does the government have an obligation to prevent you from getting quote unquote sicker, if you will? And then also rhetorically, and Jamelia Morgan talks about this, I know, in her work as well, having to use disability, sort of how bad it is or how much worse it can get rhetorically to make your legal point. So those are the two things that that case made me think of. And then in 2013, another one of my former employers, the National Center for Law and Economic Justice, brought Baez v. NYCHA, which is New York City Housing Authority, where they challenged the lack of mold remediation in New York City Public Housing Authority on behalf of tenants with asthma and other respiratory conditions. And specifically, they said that these tenants had requested remediation of mold in their apartments as a reasonable accommodation, and that NYCHA was denying them that reasonable accommodation. And actually, that case also was never litigated because it was settled. And very recently, and this made me think of Ruth's comments about the limitations of reasonable accommodation, the New York actually said that not only does NYCHA have to fix those apartments of the plaintiffs with asthma, but private developers also have to fix their housing as well. And they have to do it for everyone, not just the people who have asthma. And so all of this led me to think about what are the pros and cons of the use of disability, specifically this thing that was supposed to be so fearsome as a legal strategy. And so I'm going to put it in the language of this symposium in terms of opportunities, costs, and constraints. So the opportunities, I think, are somewhat obvious in that there's a big critique of people with disabilities being left out of discussions of environmental injustice. And we know that environmental injustice does affirmatively disable people, and that people with disabilities are disproportionately impacted by environmental injustice. So bringing claims under the Americans with Disabilities Act forces the inclusion of people with disabilities because it makes it a legal necessity. So that's one benefit. Some of the cons, or let me go to costs. So the costs are what we've been talking about all along. They are literal human costs. They are the costs of health, the costs of well-being. They're not so much the fiscal costs that we've been talking about this entire symposium so far. But what I'm most interested in are the constraints. And I didn't really have the language to describe this before the symposium, so I'm really grateful for it. But I started out talking about the framing of disability as fear or threat, but then the use of disability as innovative legal strategy. And people kept asking me like, yeah, we can see the contradiction, but what's the problem? And it's more than just irony, right? It is colloquially, I think about in the Black community, we often say, everybody wants to be Black until it's time to be Black. And what do we mean by that? We mean they enjoy the culture, they enjoy the food, they enjoy the aesthetics of being Black, but they don't want to deal with the actual social problems of being Black. And I worry about the same thing in the context of disability. What does it actually mean for communities that don't relate to you, that fear you, that don't understand you, then using your devices to advance their causes? And that's something that I want to pose because I don't know the answer to that. But I think that while the disability frame poses some advantages, it also poses some disadvantages that we need to talk about. I think specifically in the context of communities of color, who gets the benefit or the so-called benefit, if you will, of disability, of being viewed as vulnerable, that is. I talk about Saray Jarrell Johnson's work, where they talk about the paradox of Black disease. And what that means is basically people of color are often both simultaneously viewed to be so disabled as to not be able to manage their own affairs, need someone to intervene, other people being superior, and also not disabled enough to be taken seriously. And we know all of the literature that says that people of color's pain is often not regarded in the same way. And so with that, what are the risks of framing environmental injustice in terms of illness, in terms of sickness, in terms of disability, specifically in communities of color. We know that, for example, Hurricane Katrina, we saw the government blatantly turn an eye to what it looks like, to what climate justice, the impacts of climate justice look like on a predominantly community of color. And those same risks are present here. And those are just some of the things that I've been thinking about in terms of opportunities, costs, and constraints. And I'm happy to take your questions now.
Hey, this is Matthew. I want to hop in very quickly just to turn it over to Vanessa to announce our CLE code, our second CLE code. Vanessa?
The second CLE password of this session is GAME, spelled G-A-M-E.
So is it all right for me to, that's the end of the announcement, okay, great. Well, it's such a wonderful honor and pleasure to be wrapping up this session. I should say that I use she, her pronouns. I'm Dorothy Roberts, and I'm a Black, we'll still call me middle-aged woman with tan colored skin and fairly long brown, as far as you can tell, dreadlocks, but if you look closer, you'd see the gray woven in there. And I'm wearing an ivory colored sweater and bluish, greenish glasses. I'm speaking from my home study in Philadelphia. So first, I just want to say what a joy it is to see this panel, people I've worked with, Professor Colker, I can't even say how many decades it's been. Probably 3 at least, right? We probably go back 30 years or more. And others, of course, Professor Wilson, seeing you back at Penn Law is wonderful. And as well as engaging with Professor Dorfman again. And always wonderful to be with Professor Powell, whose work I admire. So I also want to thank the students on the Law Review and Professors Harris and Tani for organizing this fantastic symposium. I feel as if Professor Wilson summarized everything and wove together all the other panelists' comments so well. I'm not sure if I have much more to say, but I do want to emphasize, as she did, that all the papers concern the tension and promise of the disability frame and how that might help us imagine or reimagine how we could use it in social justice advocacy in the future. Emerging also from these papers is the tension between distinguishing between discrimination against disabled people and not making disability disappear or be used only as a metaphor of people with disabilities as pawns to further some project that then excludes them. On one hand, but then on the other hand, recognizing the intersectional nature of experiences and interlocking systems of oppression, including white supremacy, patriarchy, and other kinds of oppressions, as well as ableism. So Professor Wilson pointed out that the turn to disability law resulted a lot from the failure of civil rights law to remedy environmental racism as race discrimination, and that the reasonable accommodation provision in the ADA was seen as a positive right that was more useful and promising than civil rights law. But everyone points out as well that the benefits of using the ADA as, or the disability frame as a more progressive frame than civil rights laws may actually include limitations. Professor Colker noted that the emphasis on individuals' deserving a remedy only after they've already been injured or made sick is a real problem. And they may be the only ones who benefit from ADA litigation. Professor Wilson also noted that people with disabilities will already have to be sick, and those remedies are limited to disabled people impacted by an environmental decision. Both call on the ADA or some litigation or other strategy to seek to stop, well, both call on stopping the use of the ADA to seek beforehand solutions to seek after, I should say post. I'm pausing because I'm trying to not use the Latin terms and use Professor Colker's terms. So I think I've just mixed them up, but let me start again and try to not speak in Latin. So both of them call on strategies to seek beforehand solutions that provide structural change rather than the individualized after the fact changes that don't benefit very many people and are very limited and don't get at the roots of the structural, social, societal impairments that people with disabilities and others face. So I wondered, though, if Professor Colker's call for universal remedies that would help everyone suggests that anyone should be able to seek those structural changes regardless of disability. And would it be better to address the reality that disability is not rare but common, as she argues in her paper, to make the approach more universal? Would it then the disadvantages faced by disabled people caused by inequitable structures be addressed better, since they also disadvantage other marginalized groups? And that's the reason why structures need to be changed. Now, on the other hand, the speakers also point out the problems with the use of disability as a frame or a metaphor in legal arguments for social change, where the focus on disability and the experience of people with disabilities is diluted and sometimes even overlooked. So Professor Dorfman especially argues that using disability as a metaphor for understanding, describing, or advocating against social inequities. He points out that this can dilute the advocacy for people with disabilities. Professor Wilson agrees that also that the way that people with disabilities are used as pawns and that the disability frame often doesn't actually end up, the use of it in this way, benefiting people with disabilities. I'm reminded of a discussion I had with Adrian Ash, a fierce disability justice advocate who passed away some years ago, where we were in a workshop together actually it was on reproductive justice and disability for a symposium issue in Signs, the feminist journal. And she said that she was disturbed that so many of us in the workshop were not citing people with disabilities, and that it was wrong to make arguments about disability, and in other words, to use the disability frame without actually incorporating the words and the experiences and the perspectives of written themselves by people with disabilities. And that's stayed with me all these years. We might see this argument as in tension with Professor Colker's who seeks to expand the disability frame beyond current concepts of disability law to advocate for more universal structural change. But maybe it's not. And so I'd love to discuss that more in the discussion after I speak, and it may be in the context of questions. Professor Dorfman argues that the use of disability as a metaphor ignores and therefore undermines the historical cultural context of disability rights movement and the lived experience of people with disabilities. But is that in tension with acknowledging that many people of color, trans people, houseless people, and so on are disabled, and that the structures that discriminate against them are often inseparable from the structures that discriminate against people with disabilities? Another problem is that the disability frame is used for, when it's used for advocacy, often cast disability as the terrible outcome of inequitable social structures. And Professor Wilson especially emphasized this in showing that disability is often framed as the undesired result of environmental harm. This came up in other papers as well. Professor Powell criticized the use by reproductive rights organizations, the argument that the reason for abortion rights is to prevent babies predicted to have disabling traits. And Professor Dorfman referred to Emily Murphy's claim that poverty should be seen as disabling because it impairs children's brains. I think the underlying trouble with these ways of thinking is how they identify the problem with poverty or with abortion bans or with environmental justice as the impairments they cause in people's bodies, rather than the unjust structures themselves, blaming social inequities on individual impairments rather than on the power arrangements that create unjust advantages and disadvantages. So I thought the papers really brilliantly bring out these tensions of the perils and promises of the disability frame, especially in the context of advocating for social change. And I loved how they brought that question, which might be an abstract question, into the grounded questions of how do we strategize, how do we organize to overcome oppressive structures and to create a world without these forms of oppression. So some of the, well, I'm just going to focus on a couple ideas for sake of time that came out of the papers that I thought were really important and promising. And one is to include people with disabilities in strategizing about all organizing for social change. So in other words, instead of seeing these as separable movements and then movements that aren't focused on disability justice to exclude people with disabilities, but just use the frame as metaphor, we have to include people with disabilities in leadership and strategizing about all organizing to end the interlocking systems of oppression. I recently made a similar argument in an article against human germline genetic modification, and especially the way in which it's being debated without the input of the most marginalized people in our society. It's being debated by elite scientists mostly, and most of them white and able-bodied as far as they identify anyway. And so I argued that they have a stake in genetic modification rather than in social change, because they're privileged by the status quo. So they might see genetic modification as a way of improving their welfare, but people who are discriminated against and oppressed by unjust institutions and systems have a stake in social change, and that's not taken into account in the ethical debates about these genetic technologies. And of course, people with disabilities should be at the table discussing whether there should be a moratorium on these technologies or not. Everyone, I think, agrees that an advantage of the ADA is, as Professor Wilson said, that it forces people with disabilities to be included. But we shouldn't have to rely on the ADA to do that. We should insist that that be a part of our organizing. Secondly, and relatedly, there comes out of the papers a suggestion for an intersectional approach to movement building. How do we advocate for justice for disabled people while incorporating an understanding of how systems of oppression are interlocking? If we take, for example, eugenics, which Professor Powell wrote about, eugenic sterilization was intimately entangled with white supremacist ideology, along with anti-disability ideology. And eugenic sterilization laws went hand in hand with white supremacist anti-miscegenation laws. In fact, the Virginia sterilization law at issue in the Buck v. Bell decision was passed on the very same day in March 1924 as the racial integrity law banning interracial marriage. And sterilization programs that at one point in US history focused disproportionately anyway, if not mostly on people who were so-called feeble-minded, as Carrie Buck was described in Buck v. Bell. They started to become applied mainly against Black and Latino women in the 1960s and 1970s. So I see at the bottom of this a question of who deserves autonomy over their reproductive lives, whose sexuality and childbearing are valued, and whose are considered a social problem that needs to be fixed. That's embedded in the reproductive injustice against disabled women and Black, Indigenous, and other women of color. And of course, many have both identities. As Professor Powell notes, reproductive justice movements, the reproductive justice movement was founded by Black women who deliberately developed a praxis of attending to intersectionality. And she also notes that disability injustice is an intersectional movement, theory, and praxis that was conceived by a collaborative of queer, trans, and or racialized disabled people. Reminds me very much of the Combahee River Collective, which we could see as, I think of it as the origin of the reproductive justice movement, even though they didn't coin the term. So Professor Wilson ends with calling for an intersectional environmental justice campaign that contests the relationship between the classification and ranking of people's bodies and lives based on race, disability, and any other category. I wrote an article co-authored with Sujatha J. Sudasan in 2013 called Movement Intersectionality, the Case of Race, Gender, Disability, and Genetic Technologies. And we argued for using intersectionality for cross-movement mobilization and use a case study of the intersection of race, gender, disability, and genetic technologies as a way of organizing to promote a social justice approach to the use of these technologies. And we showed, based on our experience working in an organization called Generations Ahead, where we brought together disability justice advocates and reproductive justice advocates. And we showed how an intersectional analysis can help to forge alliances between reproductive justice, racial justice, women's rights, and disability rights. I would add, having read Professor Wilson's paper, also environmental rights activists, to develop strategies to address reproductive genetic technologies and to create genuine common ground authentic alliances that can more effectively advocate for shared policy priorities. I will end with saying that Professor Powell's call to abolish family policing is an example of that. It's a call that I'm making in my forthcoming book, Torn Apart, how the child welfare system, which I call in the book the family policing system, destroys Black families, and how abolition can build a safer world. And that's a call that I grew to as a result of my work in the reproductive justice movement and racism in the child welfare system. And Professor Powell came to it through her work as a disability justice activist and scholar. And I think it's an example of how we, using an intersectional approach and building alliances based on common values, is the most promising way ahead, without ignoring the experiences of any particular group of people, but understanding how interlocking systems of oppression create a world that is harmful to all of us, while keeping our attention, our focus, our advocacy on the particular experiences that people have, including and especially people with disabilities. So I'm looking forward to further discussion in response to the questions, and hopefully discussion amongst ourselves on the panel as well. So thanks so much.
If I may jump really quick and just say something, is that okay? All right, so thank you so much. Thank you so much, everyone. I always learn so much from Professor Powell and Professor Wilson and Professor Colker, and I really appreciate it. I want to say something about the role of impairment in disability. So I think there is something confusing to some people about the social model. There is, I think, a thin view of a social model and a thick view of the social model. And I think there was a misunderstanding of a lot of people that disability is completely socially constructed. It's only made by society. That is absolutely not true, right? People with disabilities suffer pain from their impairment. People with disabilities have a complex relationship with their impairment, and their impairment cannot be taken away from them. And I think what we can all agree is what differs or what makes it, complicated when someone else is claiming disability for another group is where there is no impairment to be found. So there is a really great article that I always refer to by Bill Hughes and Kevin Patterson. It's called The Social Model of Disability and the Disabling Body Towards a Sociology of Impairment. And I think that article is a very important one for a lot of people who are writing in the field or starting to write in the field. And I think our field needs more people to write in it. But it also needs to understand that the social model in the thin view of it, that was really great in some way because it helped create a movement, right? And create and unite people with disabilities is important, but we've moved on from it. And today we see disability as a complex relationship between the impairment, the pathology, and the social environment and the built environment. And I think that's very, very important. I think what's, in my view, important is that we don't erase impairment and we don't erase the medical view of disability. Disability is complex. It's neither or, it's both together. Thank you for that.
I'd like to jump in if I could and answer or respond to your first point, Dorothy, which I thought was brilliant and important. It's one I've thought a lot about, and I think that other speakers have said things that are related to it. So I think we can all agree that people with disabilities should be in the leadership positions, helping to make important policy decisions. But then who are those people? And so I sit on the ACLU National Board, and we have some goals for people with disabilities sitting on our board and staff and the like. And I, in part, became a national board member because they interviewed me and asked me if I was disabled. I was like, well, under the ADA, I am, I guess. Yeah, that's true. That's not why I'm a disability rights advocate, but it is true descriptively. And then when I got on the board, one of the things I did is pushed for us to have two different definitions of disability, to have a more severe disability category also, to really say that it's important that we don't, I hate to say this, but just hire people with more mild disabilities or more modest impairments who often don't need accommodations and don't challenge the world in which we live in any fundamental way. And that we needed people who are blind and deaf and use wheelchairs and have intellectual disabilities and significant mental health impairments to sort of literally be in the room. And so I just, and I know there have been some discussions like this, obviously in race areas as well. You know, there's obviously people who are more privileged in the Black community and blah, blah, blah. But I think that's something we don't talk enough about, I don't feel comfortable standing for people with disabilities. It's too broad a category for me to exercise leadership in that way. And I'd love to hear, from other people in terms of how they think about that term and how it should be used when we think about leadership.
I mean, I think I can respond. I don't think you shouldn't feel comfortable representing people with disabilities, because I don't want to introduce a gate, right? Like we know that gatekeeping comes with its own problems. There's a reason that the definition of disability is so expansive in the statute. We want people to identify with the community, but I think what you talked about is really important. We need a range of voices, experiences, and representation. So I wouldn't, as someone, my disability is apparent, but I wouldn't want to say that someone who isn't shouldn't be part of the conversation or shouldn't speak for people with disabilities, because disability is expansive.
Can I jump in for a second? I think one of the things that I talk about in my disability law class is sort of how we have to avoid sort of this notion of who's really disabled, the real versus the not, and that goes back to our deserving versus undeserving structure. So I think that we have to be cognizant of both issues, sort of that we don't fall into that trap of saying, well, Robyn's in a wheelchair, so she's really disabled, but maybe Ruth isn't really disabled. And I think we have to be sort of this umbrella tent. At the same time, we have to make sure that it's not just the same old people, the white people in wheelchairs that are at the table, which is how it's always been. That you can look at the history of the disability rights movement, and that's what it was. White, predominantly men at the table, and that had physical disability. So we have to also be cognizant that we have to have this broad, diverse group of people with disabilities, as Britney said, and really recognize that disability encompasses so many different identities. And so focusing on, in my paper, I talk about sort of making sure that we address the people who have historically, experienced multiple marginalizations helps everyone, so that we sort of bring everyone to the table, recognizing that some are going to experience more marginalizations and who have been excluded. So someone recently told me I shouldn't say underrepresented, I should say excluded. And I think that's true. So making sure that we are really making sure that those who have historically been excluded front and center at the table.
Got it. And how much time do we have left? I don't know. It would be helpful to know, just because I see lots of questions and I'm trying to consolidate them and choose some that are possible to get to. Can one of the law review
We're
people?
supposed to go to 4:30.
Oh, wow. Okay. Well, let's hope that we can go a little bit over. So one question or set of questions coming out has to do with the definition of the term disability. And I think this may be motivated in part by Professor Dorfman, your argument against using it as a metaphor, but I think it relates to everybody's talk, right? In fact, it relates to the topic you all were just discussing that Professor Colker raised. So what would be a better term for disability? Who will police the boundary of the group that is included in disability that's not a metaphor? I saw something also about impairments, right? How does the definition of people with disabilities as those with impairments intersect with the regarded as prong of the ADA? So I'll end there, but you can see the gist of these questions. Maybe everyone can comment on, if you'd like, on this question about what does disability mean and how should it be used in legal and advocacy contexts.
If I may interject really quick. So I do think, that if you are trying to invoke a disability rights law, you need to stick with the definition that that disability rights law has. So the definition of disability under the ADA is different from the definition of disability under Social Security benefits, right? For those who don't know, under the Americans with Disabilities Act, a disability means a physical or mental impairment that substantially limits one or more major life activities. You need a record of that impairment. And then you can also be regarded as having such a disability. But being regarded as such a disability, meaning that you also have that you're being regarded as having that impairment, right? So again, let's not erase the impairment. It's part of the definition. Under Social Security benefits, right, or under the Social Security Act, rather, disability is the inability to work, right? I have a qualitative research called Reclaiming Disability about what happens when a person who identifies with the more social model inspired type of a view of themselves encounters that very medicalized and extremely medicalized idea about inability to work. So I think that that's how the definition kind of work, right? And because we are legal scholars, we're kind of bound to them, right? But I do think there is this tension all the time between a person's personal identity. I think Professor KDIR talked about it, and the other professors in the panel before us today talked about it. When you have an empowered disability identity and you encounter all those other systems that might not affect the nuance of disability, that's where problems occur.
Does anybody else want to add to that?
I mean, I guess I would probably disagree with you, Doron. Disability, some of the problems that we have as a movement and as trying to figure out who we are and all that stuff is because there are 15 different statutes with 15 different definitions, and that's just peculiar. And I do a lot of special education advocacy, and whether you're disabled changes when you turn 3, and it changes again when you turn 5, and changes again in many states when you turn 8 or 9, and then it changes again when you might be 18 and go to college. That's ridiculous. You can't expect people to adjust their self-conception because the law has changed. And so I would favor, the ADA was amended in 2008 to broaden the definition. I think that's great. And I think that's where we should be headed politically as a goal, instead of bifurcating the group so that you can get some special ed benefits for a while and then they get taken away. It's crazy. Well, I don't like to use the word crazy. It doesn't make sense. It's irrational and it doesn't serve our political purposes. And but we're not going to go amend any statutes because that would be the worst thing politically. But in a perfect world, and I guess I would say that from a political organizing standpoint, we want the umbrella to be as large as possible. There's no advantages to having it be a smaller umbrella. So for my purposes, disabilities and what the statute says is what we broadly as a community conceive of it as. And I think agree with Britney, who said earlier, we want to include as many people who feel like coming into our community. We're not interested in being an exclusive club, right? We welcome everybody who feels comfortable in our community.
I think we agree, Ruth. I think we all strive for that same world. I think we just agree.
Okay, I think we may just have time. I have to end at 4:35, so we have 1 minute. Could you speak about how the ADA and the Civil Rights Act could play off each other and be used to mutual benefit as interlocking frames, so to speak?
I don't want to monopolize the discussion, but the testing example that I gave was one in which a lawsuit was filed in California to challenge the use of the SAT and the ACT by the California system. And that lawsuit was brought under Title VI, the Civil Rights Act of '64, because of the race discrimination implications and the ADA. And it was settled after some favorable lower court decisions. And it's really a great model for how to bring a race and disability claim together. And I'm sure that Britney could probably think of some examples in the environmental area as well, but it's a very powerful tool to bring them together. And I think increasingly we're going to be seeing that.
There's also a New York case against ACS, which is their child welfare family policing system. And they brought it based on both racism and ableism. And I think it was great. And what I think is great about it is it was brought in part from a reproductive justice organizing approach, which brings in all of the different marginalizations. So I think that we can see that also in reproductive justice.
Yeah, well, I'm going to end. There are other questions, but we ran out of time. And I'm not sure if I'm supposed to give the final goodbyes. I'm going to leave that, I suppose, to one of the organizers, but I do want to say how wonderful this panel was. And I love the way we ended on agreement, despite the tensions, and on this idea that we can think about interlocking ways of working together to address these interlocking oppressions that affect far too many people in our society. So I'll just end there.
Thank you so much, Professor Roberts. This was an incredible final panel, an incredible way to finish off. And thank you to each of our panelists so much. This is Matthew, by the way. I'd like to turn it over to Vanessa to read our final CLE announcement of the day.
If you are seeking CLE credit for today's event, please remember to fill out your digital evaluation form and include the CLE passwords announced throughout this event. The evaluation form is mandatory to receive CLE credits. Please find the link to the evaluation form in the chat. The last password is BALL, spelt B-A-L-L.
Thank you, Vanessa. Once again, I want to also thank everyone who posed questions. I know there were so many that we didn't get to, and we are going to post various things in our Dropbox as we've been doing. We will be posting the questions answered and unanswered that have come through, and an interesting way, or a great way, if you just want to access some more thoughts on any of the matters discussed today. Those questions are a wealth of just thinking. We're also going to release on the Dropbox our captions from today, as well as the articles and other substantive links that have gone out through the chat today. There's some really great scholarship there. We have recorded the event. We aren't exactly sure how we're going to post it yet. Believe it or not, we've never hosted video content before, so we're not totally sure where we're going to put it, but I'll follow up with an announcement once it's posted. And with that, I'm going to turn it over for some concluding remarks to Professor Tani.